Masechet Bava Metzia, page 39. We will start on page 38b, 11 lines from the bottom of the page. We sometimes, as people involved with Bet Hadin, of Jewish rabbinic court, need to make decisions that are really difficult. Here is a case. We're going today to several real cases that happens in the past, but we base it on the study of today's daf. Here we have an estate, we have a property that the owner disappeared. The question is if they disappear intentionally or it turns out that they disappeared by force of circumstance, such as if, as happened many times in Jewish history, they've been captive and therefore we are not sure what's going to happen. So if someone is in a captivity, we, the people who reside in the rabbinic court, needs to make decision what to do with his estate. It may be that he will not make it and he will never come back. So there are several people who are relatives. Some of them are heir, meaning people who are entitled for inheritance. But since it's all enigma, it's all unclear, we know someone in the family that potentially can be a yoresh, can be one of the heir. And the question is, can we designate that person to be in charge for that estate? The problem, it can be that that person go out of his way with estate without the consent of the original owner, and therefore it can be a potential damage to the estate. For example, if it's a forest that contains a lot of trees, it may happen that that executor or that relative that we have pointed out, he is a guardian, try to make as many produce possible, and he caused damages to those trees. Shimush yeter bakarka, he can in a way abuse the estate. And the problem here is the rabbis who reside in that rabbinic court needs to get to the mindset of two different entities. One is the mindset of the owner, the other one is the mindset of the relative. So we have here two view disputations. One is Rava. Rava tells us that it is a concern that that relative, that heir, can create a situation that he squeeze the estate as much as he can, and it can turn out afterward, and it's all said and done, that he's not even a natural heir, a natural inheritor, and therefore he said don't touch. Shmuel, however, said that if we can appointed someone, some trustee, some executor to be a guardian, and we define clearly what is that person's limitations and what exactly the profit or the salary that he gets out of taking care of this property at this time. It's called ke'ein aris. It's like someone who's in charge by a court appointed, and therefore we are allow certain segment of that estate to have that person as a compensation, and the rest we keep in our rabbinic court as a pikadon, as some type of deposit. Those who think about regular apotropos, regular person that can be apotropos, you see it later on that it's very hard and complicated when it's come to people who mature, bogrim, gdolim, people who pass the age of maturity. In those days, people who are appointed as apotropos, later on you see there are honorary people who are well established trust in the community, and it was part of their volunteer works. So anyway, halacha follow Shmuel, as we learned yesterday. So again, what we said, that the question is, is לא שמעו שמת. We're not sure what exactly happened to that person who taken in captivity. And we try to dig in what exactly מה היה רצונו, what exactly that person's wishes. It's a well-known story about Rav Sofer, the Khatam Sofer. It was a woman that was deserted, was aguna, and the people are very hard and pushy on him as the head of the community to allow her to go ahead and marry someone because the husband disappeared, and the Khatam Sofer was not in favor of that, especially not to do it in a quick way. Turns out that all of a sudden the husband came back, and when they asked him what exactly happened, he explained that it was unfortunately a war between Austria that in those days and France, and therefore he was one of those merchants, and during the early part of the war they stole all of his produce, and he was very embarrassed to come back home like that. So as a result he decided to go there and establish his own small business, and when he get back on his feet he come back home, which again show us that when we are in a state of quandary, when the Bet Din is in a great predicament, the dilemma is to be or not to be, right? Like Hamlet, what should we do and how? It's not as simple as sounds like just make a clear decision. So here we are, 11 lines from the bottom of page 38b. מורידים קרוב לנכסי שבוי תנאי היא. So the Bet Din allowed to send a relative, authorized individual to manage the property. That's disputation among the Tanaim, the Tanya. היורד לנכסי שבוי, אין מוציאים אותו מידו. Someone whose descent, meaning go ahead and take care of the estate of someone who's unfortunately a captive, so we're not taking it from him. ולא עוד, and furthermore, אלא אפילו שמע ממשמשים ובאים וקדם ותלש ואכל, הרי זה זריז ונזכר. So even he heard that they come and they're about to take it, confiscate, take it from his possession, and guess what? He went to the field, perceived their arrival, and uprooted and consumed produce that grew that year. It's diligent, and he profits as he receives return from all the arduous effort and work that he was involved in that estate. That's the way Rashi explained to us. Tosfot said that if the captive returned before that individual relative ate from that produce, he will get nothing. But anyway, ve'elu hen nichsei shvuyim. These are the captive's property. Cases like הרי שהיה אביו או אחיו או אחד מן המורישים הלכו להם למדינת הים ושמעו בהם שמר. When it's one's father or brother or one of those who bequeaths him inheritance, then they went to Chutz La'aretz, to country overseas, and here we see a difference between the Ravid and others. The Ravid said that it was against his will, that he was forcefully taken overseas. The Rashba and others, they said that he just went overseas for business and he didn't instruct people what to do with his estate. Second din, hayored lenichsei netushim, and soon you see the difference between netushim and retushim. Here we start with nun, hayored lenichsei netushim, one who descends to abandoned property, such as people who get being captive, motzi'in oto miyado. So therefore, we remove it from his possession of the fellow that managed it. Ve'elu nichsei netushim. Give an example. Someone is in captivity and didn't hear that he is gone. הרי שהיה אביו או אחיו או אחד מן המורישים אכלו למדינת הים ולא שמעו שבהם באמת. So So you don't ascend, לא מורידים קרוב, you don't ascend a relative, because there's a concern that he will take something that he's not entitled to take. רבן שמעון בן גמליאל disagree, ואמר רבי שמעון בן גמליאל, שמעתי שנכסי הנטושים כשבויים. I heard that the legal status of abandoned property is like that of the property of captives, and is not confiscated from the possession of one managing it. So here you have a disputation between Tana, Kamma, and Rabban Shimon ben Gamliel. Third din, היורד לנכסי רטושים, the one who descend to forsaken property. What does that mean? That one will run away. Why? Can be someone who owe money to other people. Happen, unfortunately, builders and other people build business in a irresponsible way, and they run away because they have too many people they owe money. They owe money to IRS, but because it's a large sum of money, we usually expect that person who set it up, who planned it, to leave some instructions. If he didn't say anything, we assume that he is not of interest for anyone to manage it for him. היורד בנכסי רטושים, מוציאין אותו מידו. ואלו נכסי רטושים, הרי שהיה אביו או אחיו או אחד מן המורישים כאן, ואינו יודע לאן הלכו. Here is a situation that either one of his father, brother, etc., and we're not sure what happened. Here again you see a disputation between the Raavad and the Rashba. The Raavad said, we assume that it's like he did it on purpose and with the intent not to give anyone any access and any rights. Versus the Rashba said that he just suddenly disappeared, and because it's all under tremendous stress, he left without giving instruction that someone should be taking care of his estate. What's the real difference between the one we call abandoned property and the other one we call forsaken property? Page 39, נטושים דבעל כוחן דכתיב השביעית תשמטנה ונטשתה הפקעתה דמלכה. When it's come to abandoned property, what the Torah tells us in the book of Shemot, chapter 23, V'hashvi'it, the 7th year, you shall rest and just lie fallow. Meaning, it's like they take it forcefully, like the king take it from you. The Maharit explained that that's part of our belief, our credence, that Almighty God take it. It's hefker, we need to give it away even against the owner wishes. And he said, retushim mida'atan nechtiv em al banim utasha. The other one, forsaken property, it's referring to the property that the owners vacate on their own volition. Tana vechulam shamim lahem ke'aris. And all of them, the court appraises the work as will appraise the work of sharecropper. Aheya. What type of estate? The Batra speak here. Ilei mashbuin hashta zariz v'niskarav. Maida ashbach baya. So you should take at least as a sharecropper. Ela aretushim v'hamotzi otam miyado katane. When we talk about a forsaken property, what we said that the rabbinic court remove it from his possession. So the legal status of one who labor in the field is not all similar that the sharecropper. The third explanation, Ela antushim leman, ilema lerabanan, which is the Tana Kamma. Ha'amrei motzi'in oto miyado. So for sure he's not taking as a sharecropper. רבן שמעון בן גמליאל אמר, שמעתי שלך נטושים כשבויים. If you go by Rabbi Shimon ben Gamliel, he said that I heard the legal status of abandoned property is like the one of captive property, because you have here the rights of the one who labor in the field and it's superior to those of Arisim, of share corporate. So they said, the conclusion, ki shvuyin velo shvuyin, velo shvuyin, meaning that we hold that they have the legal status of captives property, but it's not removed from their possession. כי שבויים דן מוציאים אותם ידו, ולא שבויים דהילואתם זריז ונסחר, ולא עלי שמין עלי כאריס. Over there we said that the one who does it quickly, he profit for the produce he takes. Versus here, and again, we take in our consideration the arduous effort that involved with management. Versus here, we treat it as a share corporate. So the Gemara asks, what's this different from something belonging to both? So a little introduction. Fortunately, it was a real case. It was a couple that both of them are attorneys. In Israel, the wife, she brought an estate, a place called Sharei Tikva. It's a place in Israel. And she bought a migrash, she bought a property that can be built. And they got married. She bought it very cheap years back. And the husband, who was also a wealthy individual and a judge in Israel, he invested $1 million shekel, in those days it was a lot of money, to build 3 levels with a pool and everything else. And they did not rent it, they lived alone for a long time. It was like quote unquote vacation home. Unfortunately, they involved with the disputation, the fight, and for some time, for several months, the husband lived there for like 3 months before they get divorced. Now eventually they get divorced. Now here you see a huge difference between the secular court and the Jewish court, because since it wasn't written in the Ketubah, it's treated as nichsei milog. So her claim is, you, meaning the husband, you have the opportunity all over those many years, 12, 13 years that we have this vacant home, to rent. And in those days you can get 17,000 shekel a month, which if you accumulate 12 years, to way more than your investment. You didn't do it, it's your problem, go to the wife by Jewish law. But anyway, the problem is that when a husband involved with spending a lot of money over the estate of his wife, and then they get divorced. So if you treat him as a share corporate, it's not so simple, because he has this right of nichsei milog only at the time that they are married. We try to juxtapose to sugya we study on Tractate Ketubot, page 79b. המוציא הוצאות על נכסי אשתו, they have נכסי מילוג, meaning she brought an estate, we get married, and the husband investing in that estate. הוציא הרבה ואכל כמעה ואכל הרבה. Regardless if he have a small amount of produce that he gain out of that, or it's a great expense, and or it's little expense and a lot of income, מה שהוציא הוציא ומה שאכל אכל. Past is ever gone, whatever you have, past. So the question is, when you compare it to here, for the forsaken estate, and you say that he ate only little, and why we say that he just received what he ate and not more? So you said, Aradam, you cannot juxtapose these two situations. Ketubah and Netushim, it's two different things. Not everyone hold. But anyway, המוציא הוצאות על נכסי אשתו הקטנה, כמוציא על נכסי אחר דמי. Those days, we learned in several places, the father married his daughter off in a young age. We know that in Yemenite Jews history, it happens to save those young girls from the dictator or other reasons. But anyway, it happens that she has the right of mi'un, she has the right of refusal when she grew up. So alma kevan delo samcha da'ate, because the fear is that the husband concerned that maybe tomorrow all of his investments go down the drain. Takinu leRabanan, there is a rabbinic enactment, ki hechad delo lafsidimhu, that he will not lose by the ruining of the estate. He constantly planted in order to increase the produce. Here too, the rabbis instituted on behalf of the one who labor in the field that he be reimbursed for his labor so that he will not devalue the property. The Bride said, "V'chulan shamim lahem ke'aris, v'chulan la'atu yemai." What you included in that? La'atu ehad amar Rav Nachman amar Shmuel shavui shenishba moridin karov lenechasav. As we said, someone is getting captivity, you send someone designated to be one who is executor to take care of the estate. Yatzal that if it was in his will, en moridim karov lenechasav. Rav Nachman didei amar boreh achareu keshavui. He said that if someone has run away, flee away, so it treated as someone who's in a captivity. So meaning even it wasn't against his will, not by others, since he's impetuous, he's a rush to leave, and he doesn't have the calmness of mind, therefore the Beit Din designated someone to do it. Borach mechamat mai, what exactly the cause for him to run away? Ilema mechamat karga, hainu ledat. If you tell me that he owes money to IRS, so that he attempts to evade, that is the case of one who left of his own volition. Ela mechamat mardin, speak about the allegation of murder, that in those days, the Persian time of the Talmud, they kill people for that reason. So he's like, we didn't talk, Moshe Rabbeinu afraid of Paro, right? He's afraid they're going to do it to him. So since he doesn't have a calmness of mind and he rush to run away quickly, so Rav Nachman said that you send someone relative to take care of his estate. So the chulan meaning that if the owner return, you take that fellow that take care of the estate as a sharecropper. All kind of example of someone who's taken captivity and left an estate can be, for example, a grape, can be date trees, olives. So the Beit Din sends someone to take care of that. בית דין יורדים לחסיו, ומעמידים להם אפוטרופוס, קוצר ובוצר וגודר, ומוסק. So the Beit Din sends someone to be the one who's like the sharecropper, someone who's taking care of that and authorize that relative to take care of the property. ואחר כך מורידים קרוב לנכסיו, and later on they sent someone who's relative to improve, and then he takes his part as a sharecropper. ולוקים אפוטרופה לעולם. So why you don't appoint a steward to manage the captive field always? אפוטרופה לדקני לא מוקמינן. You do not appoint a steward for the bearded, which means adult. A steward is appointed only for orphan. Those days, as we said, it was a big honor to be apotropos. And the big question is, yes, you trust that fellow, but he may feel that since I don't gain much out of that, Rabbi Nisim explained, so why bother to really take care of that? He may belittle, he may be neglected the estate, not taking care of the way it should be. That's the reason that we need to find the right person that's willing to do this effort without getting compensation. אמר רב הונא אין מורידים קטן לנכסי שבוי ולא קרוב לנכסי קטן ולא קרוב מחמת קרוב לנכסי קטן. אין מורידים קטן לנכסי שבוי. The rabbinic code does not authorize a minor to descend to the property of a captive. Obviously, why? Dilma mafsid lehu. It's a young man. He may cause to devalue the property. Doesn't know how to supervise the estate. ולא קרוב מחמת קרוב לנכסי קטן באחי מאמא. ולא, זה different גרסות, ולא, קרוב לנכסה קטן, אבל לומר את העדה להחזוקה בי. Unfortunately, it's a minor, and he is petrified, he is intimidated by the fact that this is his mother's brother. So his uncle, you know, he will not say, why you take it from me? So it can be a case that he have a father that take care of that all those years, and it may be a situation that this young man is not even aware that it's not the father estate, even he's taking care of that because it belongs to the mother, it's nechsei milog. So therefore we prefer someone from outside to do it. Amar Rava, shma mina mid Rav Huna. Amar Rava said, you derive from Rav Huna, ein machazikin benechsei katan, that one cannot assume presumptive ownership of the property of a minor. So even if you look at the possession of and use property of a minor for 3 years, it's not indicated he has presumptive ownership of the property. So here you have a clear restriction of Rav Huna that the descent specifically of relatives to the property of a minor, which means that those who are not concerned when it is non-relative who descends to manage the field, it's because there is no concern that one cannot assume presumptive ownership of the property of a minor. Rashi expanded on that, and he said that it can be a situation of chezkah if you bring 2 witnesses, and he said that he did it during the life of the father, and no one expressed their objection against it. 39b, ואפילו הגדיל. Even you have a situation that over the time that he occupied this field, the minor reached the age of maturity, so he does not assume presumptive ownership because we assume that the minor is unaware that he is the field's owner. ולא אמרן אלא באחי דאבא. We specifically speak about paternal brothers, because the rabbinic court does not authorize a relative to descend and manage the property of a minor because they're potential yoshim. However, אבל באחי דאמא are but maternal brothers, we have no problem with it because they're not potential heirs. Late land by, it's not an issue. ואחי דאבא נמי לא אמרן אלא בהרעתה. Only when it's come to land, we have a concern about paternal brothers. אבל בבתי, late land by, the houses, that is neighbors, etc., they can testify that is a part of the minor, we have no issue. ובהרעתה נמי לא אמרן אלא דלא אביד יתדע. As long as they don't have a document of division. אבל אביד יתדע קל יתלה. Everyone knows that this field belongs to that minor, so we're not concerned that they hold it inappropriately. ולא היא, the Gemara circumscribed, limited those rulings. לא שנה אחי דאבא ולא שנה אחי דאמא, לא שנה רתא ולא שנה בתה, ולא שנה אביד יתרא ולא שנה לא אביד יתרא. Lo machtinan. We do not authorize a relative to descend and manage the property of a minor to avoid a relative being regarded as the owner of the property. Here is in a way, heartbreaking story. His savta, the havelat lat bnata. It was elderly lady that had 3 daughters. Ishtavai bechada barata. She and one of her daughter turned to be a captive. Idach tartei bnata shchiva chada minayu. So the other 2 daughters, one of them passed away, veshavka yenuka. But prior to her passing, she had a baby boy. So what happened here? You have elderly lady with 1 daughter that in captivity. You have the second daughter that left a son, but she's gone, and have one surviving daughter. Amar Abaye Hechanavid. what exactly we do in the estate of the elderly lady. We don't know if she's alive, she's dead. Lukmina lichsei bida de'achata, if you give the entire estate to one of the sisters, meaning one of the daughter, the surviving daughter, you can do that. Dilma shchiva savta. It may happen that that lady, old lady, is gone, and therefore the grandson is one of the heir. Ve'en moridin karov l'nechse katan. You don't take a relative to be executive, to be in charge of the estate of a minor. On the other hand, nukminu l'nechse bida dinuka. If you give the young man half of the estate and half you give to the surviving aunt, the daughter, which means in this case you kind of divided it. The Mukhe Yosef explained that you divided it, but the way you divided it, it's problematic because we have the assumption that the grandmother and his aunt are gone. But you cannot do that. Why? Dilma lo shchiva savta. Maybe she's still alive, the old lady, and therefore if she's still alive, he has no part yet of the estate. Ve'en moridin katan l'nichsei shavui. And we do not send a young man to the estate of someone who's taken a captivity. So the Ritva tried to say that regardless, you don't put the minor in charge in the state of someone that, regardless if that person is in captivity or anywhere. But Abaye rules, Amar Abaye Hilkach. Abaye said, consequently, Palga yavina la'achata v'ilachpala mokmina la'apotropa li'inuka. So, guess what we do? Abaye said, you divide the property, divide the estate. You will give one, meaning half, to the sister, meaning if that captive died, she is the inheritor of half of the property. If the captive are alive, this is the case where the court authorizes a relative to descend and manage the property of a captive. And the other half, the idach, you establish a steward on behalf of the minor, and therefore, in the future, if things turn out clearly that old lady is gone and everything, then it will be a part of the estate of that minor. Rava disagreed. And Rava said, so if you decided to authorize outside source to be the steward for the estate of the minor, do it for the entire estate. And that's it. Eventually, they heard that the old woman died and they did not hear the fate of the captive daughter. So therefore, witnesses came in and testified, so therefore, the rule is that they do as follows. They give 1/3 to the surviving daughter, and 1/3 you give to that young man. The assumption is that at that time of decision making, he was already mature, but anyway. Or you can say that you put it in apotropos. But anyway, which means you divided 1/3. So the way he solved it, he basically said, because we are in a state of kind of quandary, so Abaye said, guess what? We're going to divide it in a way. We give 1/3 of the property to the surviving daughter, and we give 1/3 of the property to the minor, as he inherited from his grandmother by virtue of his deceased mother, and the other 1/3 of the property, which belongs to the captive sister, whose fate is unknown, we give 1/6 to the surviving sister, and the other 1/6 we appoint a steward on behalf of the minor, as perhaps the sister died, the property is his. רב אמר מוקים לאפוטרופה לדנקה, מוקים לאפוטרופה לאידך דנקה. Rava said, once we appoint a steward of 1/6 of the property, we also appoint a steward for the others 1/6 of the property until the fate of the captive sister is known. So it was I'd like to conclude with the story of the Beis Din of Rav Grossman. It was a fellow that left an estate and he died, and no surviving relative, and the only one who survived was the second cousin. So the Beit Din decided to give it to that second cousin. Days passed by, years passed by, and all of a sudden the first cousin came. It was a big to-do in a rabbinic court of Rav Grossman, and they ruled to give it to the first cousin. So the estate turned from the second cousin to the first cousin. So the first cousin came in and he says, what about all those years that the second cousin make money over this estate? I want also the benefit that get here. And the other party said, look, I thought I'm the heir. I took this estate and I invested so much in that estate to improve it and everything. So now we wanted, in addition to getting the estate, to get all the profit I get in between. It's a famous ruling of Rav Grossman at his Beit Din based on our sugya.